Hello, and welcome to the LLG vlog, your fortnightly insight into local government law and practice. You're with me, Dennis Hall, LLG Bulletin Editor, and as usual, I'm joined by Helen Bennett, LLG's Executive Director of Policy and Governance. Great to see you, Helen.
Thank you, Dennis. Great to see you. Sorry, I'm looking a bit pasty today. Lighting issues, haven't sorted that out, but
Well,
I'm
we can
good.
get warmed up by going through our latest topic, which is one that I've been intending to cover because one of the major pieces of legislation that came in towards the end of 2025. The
Mm.
end of December, government enacted three major pieces of legislation covering planning and infrastructure, employment rights, and reforms to mental health. And it's this latter one we turn our attention to today. Every large local authority legal department has specialist lawyers who work closely with their adult care social colleagues, dealing with some of the most complex and protracted cases they are likely ever to meet. And workload trends in this area are constantly on the upturn. And regular readers of our bulletin case list will know that Court of Protection cases figure significantly each week in the reported cases coming before the courts. The long-awaited reforms to the 1983 Mental Health Act aim to provide better protections for patients with severe mental illness.
Yeah, and they are long awaited, and they've been pushed back a number of times. But I think, well, it was December last year. It was the 18th of December last year, actually, that the
Yeah.
mental health bill actually received royal assent and then became law. And it really did mark a new dawn in mental health care provision following years of work by successive governments and lobbyists. And the new Mental Health Act 2025 basically reforms and replaces key provisions of the Mental Health Act 83, as you've said, which is the primary statutory framework governing the detention and treatment of people experiencing serious mental health crises, which have long been regarded as requiring modernisation. And when you think about depriving people of their liberty, their
Mm.
fundamental human rights, it's absolutely important
Yeah.
that this was looked at and got right. So the intention of the new legislation, as I understand it, is to bring outdated mental health laws into the 21st century, address systematic inequalities, and actually empower patients with greater autonomy and control over their treatment.
Indeed. Major fundamental questions here.
Yeah.
So what is the background to the changes? That's the first question we'll look at. The independent review conducted by Professor Sir Simon Wesley back in 2018 identified that the current Mental Health Act is out of step with a modern-day mental health service and is in significant need of reform to make it work better for everyone. And the reforms that the review recommended were driven by a number of problems. Firstly, rising rates of detention, racial disparities in detentions and community treatment orders, poor patient experience, and finally, the particular disadvantages felt by people with a learning disability and autistic people.
Mm. That's right. I think, and if we look at recent data, that has shown, well, I say recent data, but if we go back to 23 to 24, there
Mm.
were around 52,500 new recorded detentions under the Mental Health Act in England. That's England. Um, and that's been estimated at around a 2.5% increase, Dennis, in
Yeah.
detentions from 22 to 23. So they went up. And following a 7.7 fall in detentions from 21 to 22. Now, I suspect COVID might have been a bit at
Yeah,
play during
indeed.
that time, but nevertheless, we have seen an increase. And most people who are detained under the Mental Health Act are detained under Part 2 of the Act.
Mm.
And over two-thirds, and that's just above 70% of all people detained in hospital, at the date of the 31st of March 2024, they were detained under Part 2 of the Mental Health Act, while nearly a third were detained under Part 3.
Mm.
So increased,
Increases right
yeah.
across the board. And in 2023 to 24, 963 detentions were recorded for children and young people aged 17 and under.
Mm.
Over two-thirds, 689 of these, were aged 16 or 17. And in the same period, black people were 3.5 times more likely than white people to be detained under the Mental Health Act, and 7 times more likely to be placed on a community treatment order.
Yeah, now that is something that needs to be examined
Mm,
and looked at. Um, but let's look at what the new law means. I think
mm,
in a nutshell, really, it's the primary aims of the reforms are to strengthen the voice of parents, patients subject to the Act, and to add statutory weight to patients' rights to be involved in the planning of their care and to inform
yeah.
choices regarding their treatment. Because I think up till now, you always could have an advocate, but you were very much limited in this any say
Mm,
that you had. In fact, you didn't really. And the reforms are designed, and I'm sure there are some practitioners that would argue with that, but it certainly wasn't on a statutory footing. And the
no.
reforms are designed to ensure that detention under the Act is only used when and for as long as necessary. And broadly speaking, to limit the use of the Act to detain people with learning disabilities and autism.
Mm, mm. So briefly, looking at the key changes under the new Act, the new Mental Health Act 2025 introduces several important reforms that will influence how mental health care decisions are made. And some of the key reforms include, first, reforms to detention criteria. Detentions under sections 2 and 3 will now be lawful only where there is a demonstrable risk of serious harm to the individual or to others. Second, the initial detention period under Section 3 has been reduced from 6 months to 3 months, with
Yeah.
subsequent renewal periods also being shortened.
Yeah, I mean, my view, and I'm not an expert in the sector, but I would say that makes eminent sense
Mm,
because of the real overstepping of the human rights in relation to that detention. Um,
mm,
Patients with autism and learning disabilities um, cannot be detained under Section 3 or placed on a community treatment order now unless they have a co-occurring psychiatric disorder. I've got to get my words out, that actually meets the criteria for detention. So
mm,
there's going to need that, they're going to need that extra sort of layer.
mm.
Places of safety, prisons and police cells are no longer going to be classed as places of safety under the Act.
Yeah, that's got to be right, hasn't it,
Yeah.
as in principle? And on strengthening patient rights, the Act seeks to strengthen the rights of patients, including the right for patients and their representatives to appeal against detention, easier access to second opinions, and enhanced access to the first tier tribunal, the mental health tribunal. And in addition, it aims to enhance the rights of children and young people by ensuring that their wishes and the wishes of those close to them are more central to decision making.
Yeah, I mean, around patient representation and control, excuse me, the Reformed Act will allow patients to choose a quote nominated person, bit like the previous advocate, but to represent their interests and participate in key decisions around their care. So that seems like a more power for that person
Mm,
than was previously provided. And it will replace the role of the nearest relative under the previous act as well. And it will also introduce mandatory statutory care and treatment plans and a requirement for clinicians to consider what's called advanced choice documents.
indeed. Now, let's look at the next steps. And this is strange, perhaps. Although the Act is now law, full implementation will be gradual, with the full range of changes expected to be enacted over a period of up to 10 years.
Long time.
It is a long time, and the government has indicated that secondary legislation and a revised code of practice will be developed to support interpretation of the new legal framework. And additionally, the government has committed to producing an annual written statement detailing progress of the reforms and plans for the future.
Well, this is something we're seeing increasingly more of enactments with big swathes of delay in terms of
Mm,
implementation. Not up to 10 years, as in this case, but we see it in
yeah.
the Employment Rights Act. What I would say, though, is that it's understandable in a system that's been working for so long in a different way. These are huge changes, and
Mm,
it's just if you you can't flick a switch and all of a sudden place these provisions because the infrastructure just simply isn't there. But it does seem to me that 10 years is quite a long rolling period.
it is.
Um, so let's have a look at what's going to happen next then. as you've said, the full implementation of the bill will take about 10 years. And as I've said, is that time frame is purely there to design and designed to allow services adequate time to train and recruit staff and to ensure funding is available to deliver the new provisions. Always about the funding. Drafting and consulting on the code of practice is now the government's next priority, and that's expected to take a year. So we will definitely come back to looking at that because that will be key to understanding the mechanics of the provisions within the Act. And secondary legislation will be developed alongside the code. So it will be interesting to see, because we've talked a lot about the lack of scrutiny within secondary legislation, what that might seek to achieve and do. But specialists in this field should be aware that whilst the Act has now been passed, these changes will be at a much slower pace than might have otherwise been expected.
Indeed. And now I should mention, for those who are planning to implement these changes, LLG's next mental health conference is coming up this Friday, Friday the 6th of March. And the conference is designed for local authority adult social care professionals, legal teams, and practitioners navigating this increasingly complex legal and operational landscape. Now, the panel includes two of our lead officers, Penny Latham, Adult and Social Care and Health National Lead Officer from Sunderland City Council, and Robin Donaldson, also a national lead, who is from Essex County Council. And I understand they'll be joined by Suzanne Raab, barrister at Matrix Chambers, and Heather Plant, a principal associate at Capsticks. This is clearly a conference not to miss in light of these changes that have come in at the end of last year.
No, that's absolutely right, Dennis, because the conference brings together expert speakers to provide clear, practical guide. We're all about practical guidance on statutory duties, risk management, and of course, the latest developments shaping adult social care practice. And the day will open with the mental health law in practice, which is going to offer a focused overview of duties under the Mental Health Act and its interface with the Mental Capacity Act, alongside common practice challenges and learning from recent case law, and important, obviously, ombudsman findings as well. And it's also going to cover complex mental health hospital discharges, focusing on legal duties, capacity, risk management, Section 117 aftercare, and effective multi-agency working with NHS partners, which is crucial and tricky sometimes for local authorities. There's, like you said, there's still time to join this course. And what I also would say is that lawyers perhaps might want to encourage their directors, assistant directors, or heads within these fields within their
Good idea.
Because it's not, you don't need to be a local government lawyer to attend this conference. So have a look on the website because all the information's there.
And Helen, I understand that over the coming months there are plans to hold a course on the Court of Protection, so keep an eye out for that one too. Now, just before we go back to the new Act, are you a specialist in this area? Join our forum page and share with us how you think the new Act will impact upon local authorities. Something to bear in mind. And as I say, join us on that. It's an opportunity, it's a platform where you can share views with like-minded colleagues in this important area for local authorities. Well, that's all for this episode. So we'll see you next time with more legal insights and updates.